Good day. I am Breanne Smith, Program Specialist for the National Council of Juvenile and Family Court Judges, who is helping to facilitate today's webinar. Before we begin, I will provide you with a brief overview of how our webinar system works and how you can interact with today's presenters. On the right side of the screen, you will see a list of materials related to today's presentation. To download them, simply select the files you desire and click the Download File button. A new browser window will open confirming that you wish to download the selected files. Once you confirm, your download will begin. Just below the materials, you will see a chat box. Within this window, you will be able to send messages to the other participants in this webinar. Chat entered in the Everyone tab will be stored and may be posted online as part of the recording of this webinar. To chat, simply type your message into the white field at the bottom of the window and press Enter on your keyboard, or click the button to the right to send it. You will also have the option of chatting privately with an individual in the webinar. To do so, click the menu icon to the top right of the chat pod and select Start Chat With, then Attendees, and select the name of the person with whom you wish to chat. This will open a new tab at the bottom of the chat pod, which will contain your private conversation. You can quickly move between chat tabs as you desire simply by clicking on them. Chat windows with a new message in them will cause the tab to glow orange. The presenters of this webinar will not be monitoring the chat window for questions. So if you have a question for the presenters, please enter it in the Q&A pod at the bottom left of the screen, the same way you would in the chat pod. Our presenters will address your questions at the end of the webinar as time permits. At various times during the webinar, you will be presented with poll questions similar to the one shown here. These questions may be multiple choice, multiple answer, or short answer. As you answer each question, the webinar presenters will instantly receive the results, allowing them to respond accordingly. At the conclusion of this webinar, a survey will appear on your screen asking you to provide feedback on how we did today. We encourage you to take the time to complete this survey as it helps us determine how we can improve future webinars. Please remain in the webinar until the survey appears on your screen. The link to the survey is also available on the right side of the screen, just above the materials box. Thank you for your attention while I explain the features of our webinar system. If you have any questions, please feel free to send me a private chat message. Let's get started. Welcome to the Investigating and Prosecuting Non-Stranger and Stranger Cold Sexual Assaults webinar, hosted by the National Center for Victims of Crime. To begin today's presentation, I would like to introduce Ilsa Connect, Deputy Director of Public Policy for the National Center for Victims of
Thank you, Brianne. This is Ilsa Connect. I am the Deputy Director of Public Policy for the National Center for Victims of Crime. I apologize for our audio problems. I hope you all are hearing us okay now. I'm going to do a quick introduction, and then I'm going to try to go find our other speaker because we're still having trouble getting her called in. But I wanted to talk just for a minute about the National Center for Victims of Crime. The National Center for Victims of Crime is a 25-year-old national resource and advocacy organization that works to help victims of all types of crime rebuild their lives. And we do this through advocacy for victims' rights and funding for services and training and technical assistance. We provide training and technical assistance to those who work with survivors. We are very grateful to be funded by the Office on Violence Against Women to help communities that are dealing with untested sexual assault kits to help them create a victim-sensitive approach to reducing this backlog. Under this grant, we are going to be providing, or we are providing training such as this webinar. We have done, I think this is our 6th webinar. Most of them are archived on our website. We provide technical assistance on issues such as creating a victim notification policy. And we are creating an online resource collection that includes policies and protocols on victim notification and other aspects of working with victims in cases, untested sexual assault kit cases. We are also obtaining perspectives from victims through interviews, and we conducted a roundtable with survivors last year whose kits had been untested for many years. We learned a lot from these survivors about what worked and what didn't in the cases. Their cases all were going forward in various forums. Their kits were being tested, and we heard from them throughout the day about what was working and what didn't in those cases. We wrote a report on that, and that report is available on our website. So we have a lot of information about the use of DNA in the criminal justice system on our website. And here's our website here. This is our DNA Resource Center. All of our webinars are archived there. We have interviews with practitioners and with survivors and loads and loads of resources. So check it out. And this webinar is also being recorded and will be available in about a week on our website there. This is my contact information. If you have any issues related to or questions related to dealing with your untested sexual assault kits, you can feel free to to send me an email or to give me a call. We are also on Twitter, and here's our address there. Again, the website address is here as well. So I want to introduce our speakers today. We have two wonderful experienced speakers. Our first is Jim Markey. Jim Markey worked for the Phoenix Police Department for 30 years and retired last year, so I'm going to congratulate Jim on that. During his tenure with the Phoenix Police Department, he supervised the Adult Sex Crimes Unit, where he oversaw more than 6,000 sexual assault investigations and over 80 serial rape cases. In 2000, Jim was instrumental in developing the Phoenix Police Sex Crimes Cold Case Team. The unit has investigated over 2,000 cold case sexual assaults, resulting in more than 500 cold DNA hits. For his efforts, he has received over 30 commendations, including the Police Chiefs Unit Award. Jim is an instructor for the International Chiefs of Police Violence Against Women Institute and the United States Department of Justice. And he is the founder of Investigative Lead Training and Consultation, LLC. Our second speaker is Patti Powers. Patti Powers is a senior deputy prosecuting attorney for Yakima County, Washington, and a national speaker, trainer, and consultant. For 20 years, Ms. Powers has prosecuted child and adult sexual assault, child and adult homicide, domestic violence, and other felonies, including property and commercial crimes. Ms. Powers is recognized nationally as an expert, keynote speaker, and trainer in the areas of sexual assault and domestic violence trial advocacy. In January 2009, Ms. Powers began serving part-time as a highly qualified expert for the United States Army in sexual assault investigations. She has been selected as a presenter at each of the 5 Sexual Assault Response Team national conferences. That actually might be 6 now because I think she just got back from one. So I want to thank them both for being here as a part of our observation of Sexual Assault Awareness Month, and I will go ahead and turn over the floor to Jim Markey.
First of all, thank you so much, Elsa, for the opportunity, and the National Center for Victims of Crime for supporting this project. I am not an expert by no means. I have some information, some things I learned in the 30 years and the 14 years in the Sex Crimes Unit that I was there. I hope that some of the information that I can share with everybody today is helpful, that they can use some of the tools potentially to take back to their jurisdictions or their organizations and apply it. Again, I don't have all the answers. Some of this may confirm that you are doing things right in your jurisdiction. Some of this information you may look at and think we need to maybe take another look at how we examine our sexual assault kits or how we look at our cold cases. This first slide, the infamous subject number 1 is Mr. Ernesto Miranda, who was actually a serial rapist. And I don't want to say we're celebrating, but it's 50 years since the Miranda decision back in 1963, which was a case out of Phoenix, Arizona. And I just found it interesting that that landmark case involved a serial rapist as well. The team approach, I'm really going to emphasize these investigations, how we work together, the communication involved is really what's critical for success when we're working these types of cases. You really have a hard time individually trying to make these cases. But as a team, I think understanding each other's roles, understanding each other's limitations, and communicating gives us the best opportunity to move these cases forward in the criminal justice system. I always say you have to collect the dots in order to connect the dots. And when you look at these cases and you start these investigations, or you're working within a SART team, in order to get a solid foundation for these cases, I really think that all the dots have to be collected, and then we can start connecting those together and putting these cases together. I also believe very strongly in organizational commitment, whether it's within law enforcement, prosecution, victim advocacy. There really has to be a commitment for these teams to be successful, for these cases to move forward. And a lot of that we see today, resources are being drained. And, we're robbing Peter to pay Paul. And we are seeing and suffering some of the effects of that. But as long as we are committed from the top down, I believe that if we can provide the resources necessary, we can be successful. And I really think the organization as a whole has to be committed to looking at these cases. So I'm going to start with some real basic investigative responsibilities. I just want to emphasize that we try to remain unbiased. And I know it's very difficult because these are emotional cases that have a lot of things attached to them. There's people, there's families, there's associations, there's communities. And we still have to remain objective and unbiased as we investigate these cases. We have to be able to corroborate and support as we investigate these statements that we're getting as well. We want to make sure that we examine the evidence and we know what evidence we have and how to examine it and what's available for testing in the crime lab. And then we also have to understand, from an investigative standpoint, victimization and avoiding some of the traps that I think I know I fell into in some of the investigations that I was involved in as well. And what are those traps? Well, I know with shrinking resources, I hear the word triage a lot coming out of the law enforcement community. And essentially what that means is when you get a initial case that comes in, you do an assessment of the case and you make a decision investigatively, I think, on whether you believe this case is going to meet prosecution standards and, quote, how many resources, what sort of effort do we have that we can put into these cases. These cases, these investigations are not simple. They're very complex. They require a lot of moving parts. You have to be very skillful in your interview techniques, your crime scene investigation, your follow-up, your analysis of the crime. And I think when we start to make these decisions early on, we get into a trap that, this case perhaps won't be a good prosecution case because we do have some challenges and hurdles that we're going to have to overcome. And therefore, I don't think we should probably test the evidence in this case because I don't think it's going to show non-consent, because it maybe is a consent issue and the offender is known to the victim. And then sometimes there's a term, confirmation bias, where we believe that this case is probably not going to be prosecuted or not going to make it to the level beyond a reasonable doubt. And therefore, we maybe conduct our investigation to show that it's not going to make it to that level instead of being objective and unbiased. And so we try to confirm that theory that, well, we're not going to be able to prosecute this, therefore my investigation is going to show that. So, I brought up non-consent, and really there are some steps, and there are a lot of steps, and as you notice, the image on the upper right shows a staircase of all the steps that really you kind of have to go through in order to hopefully show non-consent in some of these cases. And I'm not going to go through all of these bullet points, but I think in order to really look at these investigations and understand whether it's going to be prosecutable, whether it's going to be reached beyond a reasonable doubt, and hold the offender accountable, we have to take these steps necessary to get to that point to make that decision. And so you have to look at the dynamics of the assault and look at the narrative that you're getting from the victim. Are there details there that you can help corroborate or support that statement? And then we really need to focus on the suspect. We know that a majority of the cases, the suspect is going to go consent. Generally what I found was, first the suspect is going to deny any contact, and then hopefully we will have evidence to corroborate contact, and then we confront him and it goes to consent. So the details of the suspect's statement is sometimes where we can show that the suspect is not being honest, is being deceitful, and that goes to the credibility of his statement. When you look at the timelines and the details, you need to document and locate your different crime scenes. And I think testing evidence, and we'll talk about untested evidence a little bit later on, is a key as well. So I want to do a real quick case study. And this was a non-stranger. It was an ex-boyfriend, and they were at a party together. Not together, but they ended up having some mutual friends, and they were at this party, and there was alcohol and some statements about some potential drugs being used. And the suspect was talking to the victim and had convinced her that he needed to get a ride home. So on the ride home, he forces her to stop. It's her car, forces her to stop the vehicle, and she says threatens her with a knife, and the fight is on. It ends up in the roadway where she says he forces penile vaginal intercourse in the roadway next to her car. She's able to, once the incident is over, she's able to get back into the car. He runs away, and she drives home. I'm going to play just a short 911 clip of the original call that came in on this. Hopefully it'll play through. Is that audio?
Yes,
Anybody hear that?
Your computer's muted, so you won't hear it.
Oh, okay. So as you can see from that call, there's a lot of things going on. And you think as your position in a SART team, how you would deal with the different elements that are occurring just in the course of that call. And as an investigator, what we need to do is now start piecing it together. The anticipation is you would think that maybe the offender is going to go the consent route. So how do we have to build a case in order to confront the suspect in this particular investigation? And one of the first things we're able to do is almost in real time, get information back from our forensic nurse examiner, who indicated that the victim had injuries consistent with her disclosure of where this assault had occurred. And we also look at other injuries, and this appears to be a cut to the hand. And one would look at that, if you've seen these types of injuries, maybe call it a defensive wound. And it's indicative that the victim's story was that she was threatened with a knife and there was a struggle over this particular weapon. So then we finally are able to locate the suspect. And of course, he's going to tell us that this was a consensual act and that the victim was reporting this as a sexual assault because she felt guilty about some other things that were occurring. He indicated during his statement to the detective that the that the sex act was strictly oral sex on him by her. And during the course of the interview, we asked the offender if he would pull up his pants, so we could look at his knees. Our theory was the way the incident had occurred was he would have been on top in the roadway on asphalt with the victim on her back. We've seen her injuries. And so he pulls up his knees, and he's got some fresh, what appear to be road rash injuries on his knees. He describes those as injuries that occurred while he was showering with a loofah, and we were able to disprove that statement as well. He also indicated that he never had a knife, and so we were able to go to the second scene, which was the victim's vehicle, where the initial assault began to occur, and started to observe some things in the vehicle, a broken signal switch that the victim indicated occurred during the struggle in the front seat, and a small folding knife that was found underneath the seat in the back of the vehicle. We were able to process that knife, and we were able to put the suspect's DNA on that knife and refute his statement that he had never had a knife or touched a knife. And so these dots were collected and then connected to be able to put this case together and confront the offender. He ended up taking a plea for about 6 years. But what happens when these cases go cold? And so I'm going to kind of shift gears a little bit and talk about some of the evidence that we may not be testing, and that may be the reason why the cases are going cold. And so if you do have in your jurisdiction untested kits, I'm probably guessing that you're going to have investigations or police reports associated with that evidence. And so we need to start looking at those reports. We need to do a complete review. We need to assess whether the victim is available, whether the victim is willing to continue to want to prosecute this case. It may be many years. There's a lot of issues that come up over the years with some of the victims that we have had interaction with our cold case team. And so you have to be very cognitive and aware and sensitive to that factor as well. You have to look at the victim's statement. And was it a statement with enough detail that you can potentially identify an offender? Is there enough detail in the statement where you can do some additional follow-up, or you can support the allegations, or you can support the statements of, hey, that meets the criminal offense of sexual assault A, B, and C. You know, maybe you have multiple cases that you're looking at, and what you want do we have enough information? Is evidence available in our property room or in the crime lab that we can help identify the offender? And then manage your information. Make sure that this is being documented, whether it's in a whether it's in a report management system or a case file, you need to make sure you document your information that you're obtaining. And then, of course, reviewing and locating and submitting your evidence, and that may be the key for a lot of these cases and the reason why they went cold. So we're going to talk a little bit about untested evidence and a little bit about untested rape kits. Now, there was a Human Rights Watch report that estimated that over 400,000 kits were out in the United States that have never been tested. That number indicated that, and this was an estimate on their part, and that 43% of those cases that law enforcement who was tasked with tracking those had no mechanism to track them. And a lot of the reasons they gave or that they found for these kits being untested were lack of resources. These investigations were not a priority when it came to resources, whether it's in the crime lab or investigative-wise. There was a lot of initial bias that they found in these investigations where the victim was labeled as uncooperative, and maybe there wasn't an understanding of the trauma that was associated with that case, and that assumption was made on the part of the investigation. Maybe it was looked at as a consent issue, and they felt that they were not going to be able to overcome the consent issue, so there was no point in testing the kit. A lot of them dropped out from a statute of limitations. A lot of the kits were not tested because there had already been a plea or the charges were filed. We found some cases when we were looking here in Phoenix that the charges were dropped because there was insufficient evidence. Well, the kit was never tested. I'm wondering if we would have tested the kit, whether that would have been sufficient evidence to support a charge. And surprisingly, a lot of times kits are not sent to the crime lab because the suspect isn't known. And I think that's being overcome, and that is being understood that the whole concept behind CODIS and DNA is to utilize that technology in unknown stranger cases. So when we look at jurisdictions that have untested kits, and it's really across the country, and I don't know of a jurisdiction that doesn't have potentially untested kits that could be looked at. I'm going to look at a couple of areas. I want to thank my friends up in Detroit that worked on the 400 project, Herb Tanner, Rebecca Campbell, and Debbie Kane. They basically realized that they had almost 11,000 sexual assault kits that were untested. And so I'll go back one slide. So they realized that the resources were not available to test all 11,000 kits. So they developed what they called the 400 project. So they randomly selected 400 of these kits and analyzed these kits and looked at what the results were. And based on the results of those 400 kits, they extrapolated out to what would we probably find if we tested all 11,000 kits. And these are the numbers that they came up with as far as what they believed if they tested all 11,000 kits would show. And so you would have to look at the analysis and whether the resources are available to do 11,000 kits and whether that is something your community or your SART team has as a goal to test them all. And is there a, I hate to use the term, is there a payoff? What's the benefit of testing all these kits ultimately when we see that these numbers show that maybe 1,200 of them will have a DNA profile matching to somebody? So a couple other projects that were out there. LA several years ago tested all their kits. They had 753 hits with 2 prosecutions to date that I know of. In Phoenix, we examined well over 2,000 cases, but almost 1,900 kits and some other items of evidence. We ended up with over 650 CODIS hits, and we actually submitted 170 of these cases for prosecution. So there are a couple states out there that have legislation to test all kits. Illinois and Texas, other states that have looked at as a standard operating procedure to test all kits is Ohio. Michigan is in discussion with a test all kit policy, and Colorado has in bill now legislation to require law enforcement to test all kits. I think this is a great opportunity for your SART team to get together and look at this issue, if you have it in your jurisdiction, and to discuss whether this is something that you want to move forward with or not. And there's a NIJ study that has looked at testing all kits as well. So what are some of the advantages of testing all kits we know about? Builds a database. You can use it as an interview tool with your suspect. It links other cases together. Some of the challenges we've talked about, the resources, the funding, storage issues. I can remember a few years back that we were always in a storage issue crisis, our organization, and how probative is the evidence in your case, and is the cost and the benefit something that you need to analyze and look at. So there are some funds out there. The Backlog Elimination Act for law enforcement agencies and crime labs in particular. There's about $117 million. It's through grant funding. That money is also going to be designated for coming next year, the SAFER Act, which will allow jurisdictions to apply for funds to actually identify, take the time and go look for these sexual assault kits and identify how many they have, and then make a determination on what they want to do with their kits. So we're going to talk about, when you decide that you're going to examine and test these kits and when they link. So when you do have cases linking based on the examination of this evidence in these kits, which we have seen a lot in Phoenix, whether it's hitting to another offender or to another case. These are some of the basic fundamental things that you need to look at in your case. And so one of the arguments that I would have for having a policy of testing all kits, and I'll use a case study for that. And these two suspects between August 2001 and November 2002 drove around a vehicle and basically abducted women off the street and drove to a second location and sexually assaulted them. There's always two suspects. The vehicle was described similar in all the cases, and the victims were released at separate locations. All the victims received examinations. 3 of the cases revealed one unknown male profile that went into CODIS. One of the cases had 2 unknown male profiles. The first 2 cases hit on each other in a case-to-case match in CODIS, but we had not identified any suspects. And so I'll just show you some of the different locations of where these occurred. Always make sure your photography is good, some of these cases. And we got all kinds of tips on red vehicles. And we were following up lots of information that we're getting from the public. We put out composites that we were able to have our victim witnesses describe the offenders and the vehicle. And based on that, one of the local news media outlets broadcast for about 2 weeks straight those composites. We received a tip about 2 subjects, Adolfo Lopez and Rigoberto Rojas. They matched the description. They were seen in a Reg Dodge Stratus. We put them under surveillance, and we watched them as they basically trolled the neighborhoods of where some of these assaults were occurring. When we identified them initially, before we arrested them, we realized that Adolfo Lopez had a prior sexual assault arrest from 1999. When we did a review of that case, we identified a sexual assault kit that had been done in that case that had not been tested. And the reason it had been tested is the policy at the time was the case was not filed by the prosecutor. And therefore, cases not filed by the prosecutor were not worthy of examination in the crime lab. And so that kit was not tested. So we did a photo lineup ID, and one of the suspects was identified by a victim. We did interviews. They made statements. Rigo made statements about his involvement. Adolfo did not. Adolfo is linked to all 4 rapes through DNA, Rigoberto through 2, and they were sentenced 14 and 18 years respectively. And I would think that in 1999, if we had done the examination at the kids, we potentially would have identified on the first or second sexual assault through DNA Adolfo, and there are the offenders. So it's connecting the dots that we have to take the time to do as investigators, as a SART team, in order to answer the questions and move these cases forward. And I am through. Is Patty there?
Great. Sorry, can you hear me? Oh, here's Patty.
Yes, hello. Can you hear me?
Yes, we can.
Great. Well, first of all, I want to take this initial opportunity to thank the National Center for Victims of Crime and ILSA Connect for the phenomenal leadership that they bring to this really important area in sexual assault prosecution. I'm honored to have this chance to discuss with you the work that I'm passionate about as a trial attorney, and that's the prosecution of sexual assault. Jim has already done a great job of talking about teamwork in this critical area of importance to victims. When I use the word prosecution, I'm not just talking about attorneys, but I'm talking about all of us, law enforcement professionals, sexual assault advocates, medical professionals, the judiciary, corrections, and the list goes on, and encompasses all of us who bring our professional efforts to this area of service for victims of sexual assault. For these next few minutes, I want to take us into the challenges and the great potential for success at trial. As all of us are familiar, rape is rape. There is no question in our minds that whether a victim knew or did not know an offender, the event of rape is a traumatizing and life-altering event. In our communities, and hence in our juries, rape, however, is traditionally reviewed as a crime committed by a stranger, in which force and weapons are used and physical injuries are left. As you and I know, a victim of sexual assault encounters an offender, whether he's known to her or not, as a stranger. And I say this regardless of the acquaintance or the relationship. Anymore, what we see in terms of our work in the courtroom, the offender is a stranger regardless of the acquaintance or the relationship. In so-called stranger rape cases that are traditionally known in our communities, consent is actually used as a defense. I'll be talking about a case later on, time allowing, where you can really see the coalescing of this phenomenon. But the reason I mention this at the outset is that this coalescence between non-stranger and stranger rape is an important consideration for all of us, because we must focus on the reality and the life-threatening nature of this crime of rape to a jury, whether or not the offender is known to the victim. And we cannot overlook at any time the critical importance of DNA evidence. We all know that non-stranger rape is a vastly underreported crime. And when it is reported, we know that it presents challenges to prosecution. We could go on for a very lengthy period of time examining all the myths and misconceptions that are focused now in the courtroom of public opinion on victims, victimizations, and offenders. What's important to know is that our fellow jurors, who are citizens who are impacted by the media and by their own life experience, have this initial question regarding our cases of sexual assault. Is it real? Is it true? That's how they begin the process. Cases of non-stranger sexual assault are cases that are replete with so-called tough issues. Some of those issues include delayed disclosure, drug or alcohol involvement, prior victimization, prior relationship with the offender. It includes a number of other issues that aren't even pictured on this screen, and you and I as practitioners are very much familiar with all of them. The message that I want to bring to you today is that we can take these tough issues, these so-called weaknesses in non-stranger rape cases, and we can literally convert them into strengths or convert them into gold at trial. The second thing I want all of us to focus on is that these aspects, or traditionally considered weaknesses or tough issues, actually are indicators of real rape. During the time that we have available, I want to focus with you on an infrastructure to this presentation. First of all, we need to bear in mind that rape is a crime that is premeditated. It doesn't just happen in a vacuum. It is planned or preconceived to some extent. Second, for the victim of non-stranger rape, the offender is a stranger at the time of the rape. He knew her. She didn't know him. She didn't see it coming. He had planned and premeditated this crime, drawing from his knowledge of her and his knowledge of the relationship. Most victims of non-stranger rape fear death, if not serious physical injury, even though they know or have previously known the offender. 3, we are focused in dealing with an area that has a high potential for repeat or serial offending. And again, DNA is a critical resource of evidence for us in this area. In terms of an investigation, and Jim has done a great job of giving us an overview of that, as we all know, we're focused on establishing evidence of the elements of the crime, which in most of our jurisdictions involve the date or time frame, the act of intercourse, which we know as rape, and the jurisdictional location. Well beyond that, however, we need to broaden our investigations to a consideration of the offender's planning. In doing so, we look at what literally is a formula for victimization. Offenders will select victims based on accessibility, vulnerability, and credibility. Let's briefly examine those. There's no question but that a victim in a relationship or a friendship or an acquaintance is accessible. She's right there. There's no question about that. The offender is very well aware of any vulnerability she has, whether it's drug and alcohol involvement, whether it is any social issue that is currently impacting her in her life. Whatever her vulnerability is, this vulnerability, including prior victimization, is known to the offender. The third component is credibility, and that's where we relate back to the challenges of trial in the courtroom of public opinion, because our communities and our societies have issues regarding victimization, and the offender knows it, whether it's he said, she said, whether it's a prior relationship, whether it's assumption of risk. The offender, in focusing on the measure of credibility that a victim may have, is very well aware of this societal issue. Looking at DNA, we are able to come to grips with some of the hidden reality of rape, and this is of great importance for non-stranger rape as well as for stranger rape. It gives us evidence of the act. We can learn valuable evidence and obtain insight as to the timeline in repeat or serial cases. We further are able to determine important evidence of pattern, of planning, as well as other acts evidence. It goes without saying, and we should emphasize again, that regardless of whether this is an offender known to the victim or not known to the victim, DNA evidence is absolutely critical to our ability as prosecutors to recreate the reality of the crime. So what do? We focus on potential evidence, and at all times we keep the jury directly in our immediate sight. Not only do we investigate with a view toward answering questions that we know potentially a jury is going to have when this matter advances into trial, but we also want to retrace step by step the offender's approach. And in a relationship, this means, again, bearing in mind that this crime is premeditated. At what point is the offender beginning the kind of engagement that we see in the sexual assault? When does his planning begin? We want to focus on the context and the behavior below the surface. And we need to bear in mind that there can be relationship stalking as well as stalking in stranger situations. We're going to focus on the offender's creation of an altered reality. The victim believes that she knows the offender. He's someone close to her, he's a friend, he's an acquaintance, he may be a significant other. He knows her, he knows her vulnerabilities, she may not know him. His creation of an altered reality may lead eventually to an abuse of trust in this situation. So we're looking then to the rape itself with evidence from the victim, from the offender, and from the environment. Looking at the reality of the crime and evidence, it all begins with the victim's disclosure. And I could go on for a long time discussing with you the treasure trove of evidence that we have from the victim who is able to disclose the sexual assault to us. In this time, however, I want us to come to view the victim's disclosure as the heartbeat of the reality of the case. In terms of our interviewing as service professionals, the victim, whether it's in a courtroom setting or whether it's in an office or whether it's in the field, it's important to use the very small word able, allowing the victim a true opportunity to tell us about her experience of the trauma of the sexual assault. Rather than asking the victim questions for chronological detail, we should allow her the opportunity to describe her experience by asking her this very simple question: what are you able to tell us about what happened? From that point, we need to inquire into psychological and physical evidence. We want to ask the victim questions designed to elicit her sensory experience. When the offender's face came towards you, as you've described, as he pins you down on the bed, are you able to tell us what his eyes looked like? I've heard victims in trial situations many times testify that his eyes looked mean or angry or violent. I would then ask, how did you feel when you saw his eyes looking this way? I felt horrible. I felt he was someone I didn't know. This question allows us to present to the jury or the trier of fact a measure of the psychological and physical evidence residual in the victim's disclosure. The victim's disclosure will also lead us to related physical evidence and to DNA. Environmental evidence may also be obtained, but again, all of this relates back to the victim's disclosure. Continuing further to direct examination at trial, we see again the infrastructure question: are you able to tell us what happened? We introduce the victim to the jury, not in very brief questions, but in questions designed to allow us to present to the jury a glimpse of who the victim was before the sexual assault, who she became during the sexual assault. Our focus will be on asking the victim questions regarding the five senses and any residual information she may have from her senses. Not all victims will have a recollection or access to all measures of experience. One of the reasons that going into sensory detail is important is that this literally is a direct connection for us with the jury. The jury may not have immediate tools on assessing the credibility of witnesses, but they have the five senses. And what jurors are doing during the presentation of the victim's direct examination, they're trying to relate to the victim's sensory experience in a secondary fashion to try to test what their experience would have been. The victim's taste of salt, the hearing of remote sound, the feeling of the offender's hand up against her neck, pressing to the point where she could almost feel it on the back of her neck. In this particular examination that comes to my mind as I speak to you, the victim had testified that the offender put his hand up to her neck and pressed forcefully into her neck, and she could almost feel the offender's hand on the back of her neck. She did not have that kind of a physical incisive injury, but what she was expressing to us that was critical was her experience not only of touch, but of attendant or associated trauma. And this allowed us to translate her experience of the reality of this life-threatening crime of non-stranger rape to a jury. So looking at the next step, we're focusing also on the emotional and psychological detail of the experience of the rape for the victim that allows us, with or without an expert, to present psychological evidence to a jury. We also will focus on what happened with the victim's life after the rape. This is how we're able to bring the crime of non-stranger rape as well as stranger rape alive to a jury. The core reality of the rape that I want all of us to bear in mind is the stranger dimension of the offender, or the big lie as to a relationship. With regard to the big lie as to the relationship, I've prosecuted stranger rapists who literally have defended with consent and have stated that they actually knew the victim, although this was untrue. So I added this to part of the core reality of rape that we're focused on. With regard to the stranger dimension of the offender, it's critical to remember that most victims of sexual assault, regardless of that relationship with the offender or the acquaintance or the friendship, will tell us that at the time of the rape they felt like they never even knew him. Again, the offender knew the victim. She didn't see this coming. She did not know him. He was the stranger. He is the same stranger that our society and our communities fear when they focus on their conceived reality of rape as just being stranger rape. Secondly, we need to remember that this is a crime of planning or premeditation, and we need to look at the stalking behavior even within a relationship. The use of control features are particularly important. And third, again, the potential for serial offense and other crimes of violence. I want to focus in these next few minutes very briefly on a case that I tried that I think illustrates much of what we're focused on today. There was initially a rape committed by this offender on August the 5th of 1991. In this case, the victim, this is his first known victim, was sexually assaulted by him. He had a nylon stocking over his face. We learned during the prosecution of the rape that the victim was someone who knew the offender, hence he had placed a nylon stocking over his face when he had entered into her home and raped her. There is a second rape committed by this offender, the date of September the 1st of 1991. The second victim is sexually assaulted or raped by the same offender with a knife. In this case, he did not use any covering over his face. The victim was someone who was unknown to him, and this was a classic stranger rape. The defendant then is prosecuted. He's imprisoned. This was before 2 strikes and 3 strikes case law in our state statutory and case law. He is in prison until the time of 2008. Prior to that time, he had been prosecuted for failure to register as a sex offender case, which again, for those persons who are present, who are corrections officers, we need to really focus on the incidence of failure to register as a sex offender and the potential of other criminal behavior. The next thing that happens, there is a rape that's committed on July the 29th of 2008. There is a CODIS hit, thanks to the DNA that was maintained from the 2 earlier convictions in 1991. This is the same perpetrator. This last case on July the 29th of 2008 is actually a stranger rape. The defendant in this case defended with a sex offense. He indicated that he and the victim had some kind of association through drugs, which was not true. In this particular case, there was another break-in or burglary. This victim was sexually assaulted by this offender with mesh over his face. He wasn't sure whether or not she had seen him. That's why he used the mesh over his face. He actually was next door at a neighbor's home with some frequency and apparently had that concern. What's important about this case, and I submit it to you, is that there is a coalescence between stranger and non-stranger rape. When victims know an offender, the offender may still be the stranger to them. Strangers may actually defend with consent, and in this case, This was a consent defense based upon a fabricated association with the victim. The verdict in this last case in 2008 was guilty as charged with rape 1 and burglary 1, and this offender is spending his life in prison. For a victim, there are no cold cases. For victims, the crime of rape never ends. The evidence, however, remains. Thanks to the leadership of the National Center for Victims of Crime and other states that are exercising leadership in the maintaining and the testing of all rape kits that have been provided by victims of sexual assault, the evidence remains. This is the reality of the crime of rape that we bring to the jury with DNA. Thank you.
Thank you so much, Patty. And Jim, I'm looking to see if we have any questions. And right now it looks like we don't. If people want to send any questions in that they have, or you can email to Patty or Jim, I don't think we had your contact information here, but I can certainly send it to folks. If you have any questions for Jim, you can email them directly to me. My address is up here. I just want to thank our speakers today. Have very valuable insights from years of working these cases. I learned a lot, and I've been looking at this stuff for years, so I definitely appreciate you taking the time to come and speak today. I want to remind everyone to fill out our evaluation. There's a box that says evaluation. It gives you the address. It's sort of in the middle of the screen, our address at SurveyMonkey to take our evaluation. That helps us to helps our presenters and helps us to turn in information, of course, to our funder about how well we're doing on our webinars. I want to remind you that we recorded this webinar and it will be available later on our website at our victimsofcrime.org/DNA. Also, check out that website for upcoming webinars. We have a few coming up, one more in Sexual Assault Awareness Month about the neurobiology of trauma and sexual assault cold case survivors with Dr. Rebecca Campbell. We had this webinar before. It was so popular that we decided to do it again. And we will have another one coming up in June about working with communities of color and issues related to untested sexual assault kits. So those are coming up in our future, and I encourage you to check out our website and sign up for those. We do have a couple questions, actually. We'll take a few, but we're running over, so let's see what we have here. Oh, sorry. It's hard to read this for some reason. Hang on one second. Oh, I cannot. I'm sorry. I cannot read this question for some reason. It won't come up. Sorry
How
about
about we read it for you?
Yeah, read it, because it's cutting off on my screen. Thank you, Zachary.
Camille asked, do you have any suggestions about how to make an approach to the victim of a cold case when there has been a CODIS hit? C-O-D-I-S.
Can I answer that real quick, actually?
Absolutely.
This is something that our OVW project is very focused on, so I encourage you to email me. This is work that we have collected information from not only survivors in cases like that, but also how other communities are doing it. We have, in fact, the policy that the Phoenix Police Department used when Jim was there, that shows how they work with survivors. But Jim, you've also done this, and maybe you want to mention a couple tips and lessons learned from your experience doing it directly with victims.
Yeah, thank you. Good question. I don't know if there's a right answer. We saw pretty much the range of emotion, the range of interest, the range of denial with the different victims that we would approach. We would try to be very upfront with the information that we had. A lot of times, because we are dealing with an emotional crime and we are dealing with people, I don't know if there is an exact approach. We would always try to do it in person. If the person was out of state, we would try to have law enforcement or investigators do it in person. And we would always have, or at least have available an advocate or advocacy support at that point. And a lot of times they would not make decisions when we approached them with the CODIS hit. And we allowed them to kind of digest that information and see what they wanted to do.
If I could also contribute just very briefly, I think the focus needs to be multidisciplinary. It's not just a function of law enforcement or prosecutors. We need advocates to help us in this process of victim notification. When we've made notifications, one of the things we look at is providing information that there's an investigatory lead, an update on an investigation. Depending upon what jurisdiction you practice in, there may be some issues or concerns with advising the victim about CODIS and DNA. There have been arguments made that a victim's awareness of DNA may color some aspects of her memory, for example, having to do with clothing or different aspects of the person's physical appearance. So we need to take some care. This is case specific. But I think the most important thing is to respect that when the victim is notified of an investigatory lead, she may literally be suffering from PTSD still, since this is a crime that never ends. And this notification will again bring it to the forefront of her mind.
There's one final question. Is there any specific information that we know that perpetrators look for when getting to know their victims or targeting their victims?
One of the things that I think is key in this area is that offenders develop a sense of vulnerability and whether or not a victim may be potentially believed. Vulnerability may be just, for example, someone who's been involved or is involved with drugs and alcohol. It may be a person who is homeless. It may be a person that's coming out of a difficult relationship whose self-esteem is challenged during that period of time. But they do look for vulnerability. The next component that I think we need to focus on is what the offender's view of credibility is. And by that I mean whether or not the offender believes that the victim is going to be believed. Alcohol-facilitated rape is a great example of this particular issue. A number of offenders have made the point, you think someone's going to believe you were drunk, nobody's going to believe what you have to say. Go ahead and report it. So I'm using this just as an example of an offender's knowledge of vulnerability and his conception of social credibility, and as to whether or not the victim is going to